This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Supreme Court Clerk Jim Hibner, for that introduction, and thank you for the work your staff does at the AOC for making these Zoom arguments possible and having them posted and streamed live on YouTube. We also are making available the audio portion of this to the citizens. This court has been trying to give more access to our court proceedings than at any time in our history. I hope it is beneficial to our citizens, and it seems to be working pretty well for us. If you don't mind, Mr. Clerk, I'll have you to call the next case, then I'll make some more explanations to the attorneys.
State of Tennessee versus Joshua Travis Griffith.
Thank you all for being here today. It's a pleasure to meet. I want to introduce the panel of the court. To my right, Bobby Holloway from Columbia, Tennessee, and my left, Judge Bobby Wiedemeyer from Nashville, Tennessee. I'm John Everett from Huntington, Carroll County, Tennessee. Each side is given 20 minutes. The appellant may have reserved time upon introducing herself to the court and telling me how much time they wish to reserve. I will try my best to help you keep up with the time. With that, we'll call for the appellant, and your time starts now.
Thank you, Your Honors. Brennan Wingirter on behalf of the appellant, Mr. Griffith. And may it please the court, I'd like to request 3 minutes for rebuttal, please.
Yes, ma'am.
Thank you, Judge Williams. Your Honors, we've raised a variety of issues in our brief, but I think that this case comes down to one simple question. Did Mr. Griffith receive a fair trial on the charged offenses of aggravated statutory rape when the jury also heard testimony of an uncharged sex-related crime and numerous uncharged sex acts? The answer to that question is no. Mr. Griffith did not receive a fair trial because all of these other bad acts were inadmissible and highly prejudicial. Therefore, we're asking the court to reverse his convictions and either enter judgments of acquittal or at least remand for a new trial. Now, I think there are a couple of different ways, and as you can see this in our brief, the way that we've raised the issues, there are several different ways to get to reversible error in this case. And I'll be happy to answer the court's questions on any of the issues as they were briefed. I think for purposes of argument today, I'd like to focus on 2 issues. Number 1 is the fatal variance that occurred between the 3 specific sex acts that were alleged and elected by the state and the proof that subsequently came out at trial about numerous other sex acts between Mr. Griffith and the same young woman who was the alleged victim of the statutory rape charges, even though Mr. Griffith was not charged with any of those other acts, and even though those other acts were not included within the scope of the indictment. The second issue I'd like to address is the violation of Rule of Evidence 404B that occurred when the state presented testimony and argued extensively that Mr. Griffith had transmitted the hepatitis B virus to the same young woman. Again, even though Mr. Griffith was not charged with the criminal offense of knowingly exposing another person to that virus. As to the variance issue, Your Honors, the state indicted this as 3 separate counts of aggravated statutory rape. Essentially, the indictments read as 3 counts of unlawful sexual penetration of Savannah Haley, who was a 17-year-old who admitted that she initiated a consensual sexual relationship with Mr. Griffith. The indictments were limited to those 3 counts. The indictments were also limited to a specific 6-month window, March 1 of 2017 to September 1 of 2017. Those 3 acts, that specific 6-month window, was repeated by the state in its pretrial request for notice of Mr. Griffith's alibi defense. That was the same window alleged there. And in Ms. Haley's Child Advocacy Center interview, she said, "We had sex 3 times. There were pretrial discussions and emails between defense counsel and the prosecutor. And again, the state assured the defense, this is the time frame that we're going forward with at trial. Trial starts And during opening statements, the prosecutor elected the 3 specific sex acts that were alleged to be each of the 3 bases for the 3 counts in the indictment. Prosecutor told the jury there are 3 acts here, 1 each of oral, vaginal, and anal sex. And again, we still have that same 6-month time frame ending on September 1, 2017. That's how the proof developed. That's how it went up until the redirect examination of Ms. Haley by the prosecutor, at which time the prosecutor invited her to tell the jury that in addition to those 3 acts, she and Mr. Griffith were allegedly having sex about every other weekend up until March of 2018. That is obviously many more times and for many more months than what the state had alleged in its indictment, what it had put in any of its pretrial notices to the defense, what had been discussed with defense counsel, and what had been elected at the start of trial. The problem, when that testimony came out, the first problem obviously was the testimony itself. That's the first error of how this came out. When that testimony came out on redirect by the prosecutor, the next error is when the prosecutor moved to amend the indictment with the jury still in the courtroom to include that additional time frame through March of 2018, which obviously included this testimony, these allegations of these additional sex acts. The defense obviously immediately objected, and at that time, the trial court excused the jury. Now, during that jury out hearing, the state argued that it could amend its indictment to include those acts. The trial court ultimately correctly denied the state's motion to amend its indictment in the middle of trial. But the court then incorrectly denied Mr. Griffith's motion for a mistrial, which was based on the jury hearing all of this inadmissible evidence. The way that the issue was discussed during the jury out hearing was that if this evidence had been disclosed to the defense beforehand, it could have been subjected to 404B. Obviously, it was not because of the way that it came out at trial. The defense was clear to the trial court.
And how do you say it came out in trial?
It was during redirect examination, Your Honor. The prosecutor was questioning Ms. Haley, the alleged victim of the statutory rape, and they were discussing what she had told the CAC interviewer and how many times and when she and Mr. Griffith allegedly had sex. And that is when she said almost every other weekend. And upon further prodding by the prosecutor, said until March of 2018. It was on redirect examination.
All right. The state is offering a scenario that looks a little bit different. They're suggesting that the defendant opened the door for this type of testimony. What is your response to that?
They're suggesting that, Your Honor, and it's absolutely not true, is my response to that. And we pointed this out in the reply brief that the state's brief did not cite a particular part of the cross-examination that supposedly opened the door. And the part of the cross-examination that I think that they would refer to is where defense counsel is trying his case based on what the state had disclosed prior to trial. And the state saying, we're going forward with 3 specific acts during this specific time frame. The defense's theory was at least some of those acts, counts 2 and 3 particularly, did not occur during that time frame that the state had alleged and elected. So during cross-examination, defense counsel was questioning Ms. Haley about the timeline. And she did eventually admit that she could not say exactly when they occurred. And this is on page 65, starting on page 65 of the trial transcript. Defense counsel is asking her about the 3 specific encounters. And she says, well, we did those 3 things, but more than once of each of them. Defense counsel says, but just those dates, right? And she says, I'm not sure what you're asking. And he says, well, you've testified about 3 different particular times where you had sexual contact with Mr. Griffith, right? She says, yes, but there was more than that. But from what I got, those 3 were the important ones. What then goes on to be borne out in this record is that the prosecutor knew before trial that Ms. Haley was alleging additional acts other than the ones that were indicted and elected, even though that's not what she told the CAC interviewer, and that's not what the prosecutor told the defense. All that the defense knew was 3 specific acts during this specific time frame. But apparently, in the middle of trial, we learned the prosecutor knew all along that there was these other allegations out there. He clearly attempted to limit her testimony at trial, but that did not happen. And so when she says those 3 were the important ones, later it's borne out. It was, and she says it was Mr. Tom, that was the ADA, told me those were the 3 important ones. So it's clear that the prosecutor knew that those were out there.
Well, did y'all just ask a question you didn't know the answer to?
No, Your Honor. It was not a question they did not know the answer to. It was a question to try to pinpoint the timing. She then responds, yeah, but there's more. Defense counsel.
I'm reading the same thing you're reading, and those were the only sexual encounters between you and Josh. Is that right? And she said, no, there were more. So you didn't know the answer to that question, or you didn't ask. You didn't ask your own client.
Actually, no, that's okay. So actually, there's a statement by Mr. Griffith in the record. He admitted that they had sex more than once, but fewer than 5 times. So at this point in the cross-examination, her saying, yeah, but we did them more than once. That is not the kind of problem that we have when the prosecutor on redirect gets her to say every other weekend for 7 additional months beyond the scope of the indictment. At that point in cross, defense counsel says, yeah, okay, we'll come back to that. Of course, never coming back to that and moving away from it. The prosecutor then invites her to say every other weekend until March of 2018. That is the prejudicial nature of the other acts, not what she says on cross, which they were able to back off from, but on redirect, where she, and again, invited by the prosecutor who asked her, were you having sex as late as Thanksgiving, November? The prosecutor is asking her a question about sex acts outside the scope of the indictment. There's a specific question about the timing of when those additional acts occurred. The prosecutor knowing full well that the time frame in his indictment ended on September 1, 2017. We know he knows that full well because he then moves to amend the indictment after this testimony comes out. He saw he had a problem that counts 2 and 3 were not falling in the time frame he had alleged in the indictment. And so that is why he moved to amend and why the defense, of course, objected. And then we have the jury out hearing. So the prejudicial testimony comes out on the redirect, not on the cross, which if the cross had been left at what it was, we don't have the kind of significant prejudice, the kind of prejudice that the Supreme Court of Tennessee has said is inherent in these kinds of cases and is not harmless. So
let me ask you this. So there's 3 specific incidents in the indictments. And the defendant had admitted, and I assume the victim's grandmother testified, that the defendant admitted to her that he had sexual relations with her granddaughter. Did he admit to those 3?
No, Your Honor. And okay. Yes, his statement was much more vague. Yes.
All right. When he admitted to the investigator that he had sexual relationships with the victim, did he admit to those 3?
No, Your Honor. There is no admission to the 3 specific acts that the prosecutor elected.
And when he admitted at trial that he had sexual relationships with the victim, he just said it was 5 times.
That's correct.
Did he ever allege that any of the incident the victims were talking about occurred after she became an adult?
That was the defense theory at trial, was that the at least counts 2 and 3 occurred much later than what the prosecutor had alleged, which gets you kind of starting to get up against her 18th birthday. And then the second kind of aspect to that defense was that he did not have the requisite mens rea in assessing her age. And so the timing.
Is that relevant?
Yes, Your Honor. Yes, Your Honor. Whether he acted recklessly or knowingly with respect to her age is a defense to the aggravated statutory rape charges.
Okay, the aggravating factor was her mental disability or his age?
His age, Your Honor. Her alleged disability was not really ever borne out in the record. It is certainly indicated that there was some sort of developmental issue there, but I would point out that she was 17, she was 19 by the time of trial. She had gotten married and moved out of state, and she admitted to initiating the contact.
I guess 27 at the time of this incident, right?
Yes, Your Honor. Aggravated is more than 10 years older. That's correct. And so
I want to ask about one other thing, because I want to be at least sensitive to this. Is it appropriate for us to talk about this in the context that you started, that this was a consensual sexual relationship?
So she cannot legally consent, Your Honor. I'm using her words of she agreed that she it was not forcible rape in any way.
I think I really do get that, but I think to be fair, we need to point out that Tennessee has decided that under the facts of this case, this young lady could not have consented, whether she
yes,
thought,
of course, Your Honor.
whether she thought she did or not. But
yes, I apologize if I didn't make that clear.
That's an issue I'm a little bit sensitive over, and I think other people are as well. I just wanted to make sure we didn't leave that impression. That,
yes, Your Honor. Of course, I apologize.
No, that wasn't your. That's not on you. Thank you. You may proceed.
Thank you, Your Honor. And so to get back to how this is prejudicial, again, the Tennessee Supreme Court has said over and over and over again, and actually Your Honor's raised this point in the case right before mine about when we have other acts that are similar, and in this case, nearly identical to the acts for which the defendant is on trial. It is inherently prejudicial, the Tennessee Supreme Court has said. And here, the defense was prohibited from getting a 404B hearing on these other acts because they were not on notice of these acts beforehand. This is where this sort of gets into an election issue. I'll be honest, where it's kind of confusing whether this is a variance, election, sufficiency. But I point out, and we point this out in our reply brief, that when the state elects offenses, it has to elect offenses that occurred within the time frame alleged in its indictment. And even if the state tried to elect counts 2 and 3, the specific acts that it started with, there was not proof beyond a reasonable doubt by Ms. Haley's own testimony that those 2 counts occurred within the time frame of the indictment. So when the trial court denied the defense's motion for a mistrial and then trial resumed, another problem here is that the trial court never told the jury, you have to determine whether only those 3 specific acts fall within the time frame of the indictment. Trial court also never told the jury, you can't consider this testimony about all the other uncharged conduct occurring through March of 2018. And because the jury was not told, we are restricted to the time frame. Even though the trial court and the prosecutor discussed that during the jury out hearing, the jury was not told that. And so we get to prejudice here because there are so many uncharged acts. The jury is left with, well, she says that they were continuing to have sex. That's enough. We don't know that the jury restricted its deliberation to counts 1, 2, and 3 as they had been alleged and as they had been elected. I think that covers. I know there's multiple errors there that I've talked about. I think that covers the uncharged sex acts. If I have a little bit of time, Judge Williams, I'd just like to briefly touch on the hepatitis B evidence, because that is yet another error here under 404B.
Try 2 minutes and then you'll still have your 3.
Yes, Your Honor, I'll do that. The hepatitis B evidence, the defense actually was put on notice that the state was going to try to introduce this evidence, unlike the other uncharged sex acts. So the defense did file a pretrial motion in limine to exclude it under Rules of Evidence 401, 402, 403, and 404B. On the morning of trial, the prosecutor told the trial court, this isn't even a 404B issue. It's not a bad act. The trial court agreed, but nevertheless allowed the the hepatitis B evidence to come in, finding that it was relevant and that its probative value outweighed its prejudicial effect. To its credit, the state on appeal has correctly conceded 404B absolutely applied. The problem is that the state says that the trial court substantially complied with Rule 404B procedure, and that is absolutely not true here. The trial court did not apply 404B to the hepatitis B evidence. And again, I'll skip ahead to prejudice because I think that that is really the key here. All this court has to do is read the prosecutor's closing argument and his rebuttal argument, where more than once, more than twice, the prosecutor told the jury, if you are going to believe Mr. Griffith about whether he knew her age and his version of events on the aggravated statutory rape charges, you have to believe he's sorry that he gave this young woman hepatitis B. And how credible is that? That is a direct link between propensity, character evidence, and the criminal defendant's credibility, which 404B says is exactly what the state cannot do. So if you look at that in itself, Your Honors, would be enough for reversible error. But we've also raised cumulative error where it has so that the court can look at hepatitis B and the uncharged sex acts together. And again, I'll save the time for rebuttal and ask the court to grant.
If I can ask one question before we leave this point, because you said that the state gave you notice that it intended to introduce the hepatitis B evidence, unlike they did with the prior acts. And again, I go back to what Judge Williams said. The state is not the one that brought this up first, correct?
Brought up the uncharged sex acts.
So how can they give you notice about something that you brought up? That as far as the record shows, they never brought it up, and you don't have any proof they intended to bring it up. The defendant brought it up. Well, how are they supposed to give you notice of that?
So the record shows that the prosecutor was well aware of these acts before trial. And so I'm not sure if that's answering your question directly, but the prosecutor was aware that this could possibly come out. Here, I guess the bottom line is,
he was aware of it and never brought it up. How does that? I mean, again, I go back to what Judge Williams read. The defendant asked her specifically that very question. And now you're criticizing the state for not giving you notice that they intended to introduce it. And there's no proof, as I can see in the record, that they ever intended to introduce it until the defendant brought it up.
Until you get to redirect, which again, if there's no way that the one,
right? You brought it up in cross.
And I guess that's where I disagree, Your Honor, because her answer on cross was not the prejudicial answer that we got on redirect. On cross, it was limited to, it was those three, but we did them more than once. On redirect, it was every other weekend until March of 2018. Those are very different answers.
We're talking about offenses that have elements of the age of the victim, the age of the defense, and intercourse. And that's basically it, period. Those are the three elements of statutory rape and aggravated statutory rape. And I guess I made my point. I just don't understand how you can say the state didn't give us notice that it intended to do this when there's no proof in the record they intended to do this until the defendant brought it up.
I understand Your Honor's point, and I guess my response to that is on cross, the defense did everything they could to minimize the harmfulness of that one isolated statement. It was not until redirect that the prejudicial comments came out and that the prosecutor himself led the victim to talk about incidents beyond the scope of the indictment, which is exactly what the state cannot do. Once it alleges a specific time frame with specific counts, this is not a generic indictment. This is not an indict broad and elect down situation. They alleged 3 specific acts within a specific 6-month window. They can't just disregard that at trial. And the prosecutor very clearly did that on redirect.
It sounds like arguably they were allowing the witness to explain her answer she gave on cross.
And that point, Your Honor, I'm not sure that allowing her to explain that answer was necessary. I think the state says, oh, well, it went to her credibility and her corroboration, which again, that's what all of this came back to, was the state saying, oh, it's about credibility corroboration. It's exactly what 404B is meant to exclude. That is not the purpose of this kind of evidence, especially in sex crimes trials.
Okay. All right. Thank you.
Thank you, Your Honor.
Let's hear from the state.
Thank you, Your Honor. Good afternoon. May it please the court, Austin Watkins appearing on behalf of the state of Tennessee this afternoon. Your Honor, the state would ask you to affirm these judgments for aggravated statutory rape because the state presented legally sufficient evidence as to every offense, and this trial court properly exercises its discretion to admit proof that the defendant or that the victim contracted an STD from the defendant. And there was no error in the state's questioning with regard to uncharged sex acts. So, Your Honors, I'm happy to pivot to whatever is going to be most helpful to the court first. Similar to the appellant, I think it's helpful to focus on the facts because the way the proof was borne out in this case is very relevant to whether there is any problem with uncharged acts. The state generally agrees with the procedural history and the charging description and the testimony of the victim on direct examination. This was a specific indictment with 3 offenses alleged to have occurred within a specific time frame. The state then put on its proof through the victim only as to 3 specific offenses, 3 incidents. And then during cross-examination, the defendant opened the door to 2 topics that then on redirect examination, the state followed up on, which ultimately led to 2 separate, very limited statements about uncharged sexual conduct. And so what happened, and Your Honor, Judge Williams read the transcript. We pointed out in our brief, we stated, we have a whole separate subheading for the relevant testimony where we quoted the transcript to show the court what's at issue here. And it is very clear that during cross-examination, inexplicably, no reason relevant to the defense's theory, it asked that question of the victim more than once, eliciting, fishing for this, but it only happened 3 times, right? And it is not related to the timing of the 3 specific offenses. The defendant did that. He extensively cross-examined her about the timing, but it opened the door on cross-examination to very general, open-ended conduct, and the victim answers truthfully. Oh, well, yes, it did happen more than the 3 times, but I thought I was only supposed to talk about the main ones. And so, wisely, the defendant doesn't dwell on it too long, but he does ask several questions of the victim where she makes it very clear, yes, there were more than just these 3 incidents. So, Your Honors, the defense may not have been intending that to be a credibility attack, but when the jury hears that topic of discussion, it would be natural for a jury to think, maybe the victim wasn't being completely truthful about her testimony, on direct examination. So the prosecutor then quickly comes up and follows up on that, and he tries to use leading questions to be very specific. And what he's trying to get the victim to tell the jury to kind of be clear is that when they were reviewing her statement to the CAC, person, in the statement, she only made three alleged or identified 3 incidents. And then while they were reviewing it, she told the prosecutor, well, there were other things that happened. And the prosecutor was trying to get her to avoid this whole situation and only talk about the 3 specific things we have charged. The state was trying to do the right thing here by limiting this testimony to avoid, unnecessary prejudice to the defendant about the charged conduct. And so when he comes in and tries to ask her about this on cross-examination, she unfortunately, when he asks her, do you remember when we watched this statement and you told me these things, did you tell the CAC person that all the time? And she says, I think so. I think I said every other weekend. Well, it's kind of unclear what that means, honestly. Did she say every other weekend with regard to how, the time in between the 3 acts, or was it we've just always had all kinds of, sexual relations every other weekend? So it's a non-responsive answer to what the prosecutor is doing. It's not trying to elicit that for the purpose of sneaking in a bunch of, uncharged conduct, because what he's trying to get the victim to kind of remedy is that, whoa, I'm supposed to only be talking about 3 things, and that's what I want to limit my testimony to. Well, then the defendant compounds the error by objecting to the prosecution's limiting, leading questioning, which the trial court sustains, and the victim never actually understands the prosecutor's question and never answers it fully. That is borne out in the record. And so the prosecutor moves on. So we have 1 instance of her saying, I think I told the CAC person every other weekend. Well, then, because of the bulk of the cross-examination focused on the timing of the offenses, I mean, it was very thorough and very effective cross-examination at getting her to admit, well, I know that the first incident happened in the middle of August, which was within the time frame in the indictment. I know that the second incident, I don't know the date, it was within a month after the first incident and, a few weeks later. I don't know at all when the third event happened with regard to, temporally, how close it was to the first or the second incident. And she, they asked her, like, well, so you don't know that those things happened within the time frame of the indictment? And she's like, no, I don't recall when those things happened. So naturally, the state follows up on that during cross-examination. You can read the full, where it starts and finishes for that cross-examination. The prosecutor is not fishing for more, evidence of uncharged conduct. It is always only focused on the three acts that it elected in its opening, that it charged in the indictment. And it also is suspecting there's a problem when these events fall outside of the time frame in the indictment. So the prosecutor is trying to revisit that to see if she can kind of peg the second and or third event back into that window that ends on September 1st. And one of the things that he's trying to do is trying to figure out, well, when's the latest that the third charged incident could have happened? And so he asks a question about, well, would it still have been possibly as late as November? Were you still having sexual relations at Thanksgiving? And then she says, it went on until March 2018. Again, a non-responsive answer to a legitimate cross-examination regarding the time frame of the alleged incidents. And so, Your Honors, I mean, that is completely proper cross-examination. Those answers were non-responsive. And the defendant did not object when either of those pieces of information came in. And the state would acknowledge that ideally, none of that testimony would have been admitted. It is not relevant to those three offenses. It would be 404B uncharged evidence. But it was not something that the state ever was intentionally eliciting. And the only reason it was even asking the questions it was asking was to very legitimate, redirect examination. And it was not the first time that the bell had been rung on whether there had been more than just the three incidents of sexual relations. And so, sure, there's plenty of case law that says it shouldn't have come in. The state doesn't argue that case law doesn't apply. It just says we were never trying to bring it in. You were the first person to get her to say that, and then we have the right to try to clean it up. And then when it came in, again, there's two very narrow pieces of testimony where she talks about, and they're in different parts of the redirect examination. The state was not linking together every other weekend until March of 2008. I mean, that was not the tenor of her answers, and the state was not attempting to portray the nature of the sexual relationship with the defendant in that manner. So the state was not attempting to capitalize or, disproportionately respond to the opening of the door during cross-examination. It was trying to respond specifically to what, the nature of the questioning during cross-examination. So that is not something that can be held against the state, that the defendant opened the door to this testimony that then came in subsequently on redirect examination. And it was very limited amount of it. The defendant did not object when it came in. He didn't ask for a limiting instruction. So the state didn't even get a chance to say, sure, disregard. Ultimately, the jury, in the jury instructions, we quoted them, they were told to only consider three events, three separate acts, one of oral sex, one of vaginal intercourse, one of anal sex. And then it also said it on the jury verdict form that each one of those counts was tied to that specific thing. And the state, in its closing argument, never shied away from its initial election during opening and the indictment that it was only pursuing three incidents the entire time. And so, Your Honors, the state feels confident when you read the testimony and the way it happened that the state was not improperly eliciting this testimony under Rule 404B. So that is its own issue with regards to the uncharged sexual conduct. Now, the appellant has kind of tried to also suggest, well, maybe there's a 404B problem with you not matching the three specific events to your time frame. And the state suggests that that is not a 404B problem. When the state is only pursuing the three alleged charged conduct, events, that there's not a 404B problem. 404B and all of these sex crimes exception to it and this, that, and the other, that is limited to situations where under 404B, the state is generally putting on broad proof, including uncharged sexual conduct, and then at the end of its proof is electing which offenses it wants the jury to consider specifically. It's not what happened here. The state was always only trying to put on and ask the jury to convict on 3 separate sexual acts and incidents. And so the problem, if there is any problem with the 2 of the 3 offenses, because everyone agrees that the first offense fell within the time frame, so there is sufficient evidence for that. It's not a sufficiency problem with regard to the time frame. We cited the case law that timing of the offense is not an element of the offense. Therefore, the state doesn't have to put on any proof of the timing. The time frame is relevant to notice, and it's a variance question. So under the question for fatal variance with regard to the 3 charged acts not occurring within the time frame, because they didn't occur within the time frame based on the victim's testimony, that doesn't convert them into uncharged acts. It was always the entire tenor of the trial was that it was the same 3 acts. The time frame was just moved back a couple of months. And so that is a variance problem, potentially. Was there prejudice to the defendant? Did he have adequate notice that the nature of changing the timing somehow affect and impair his ability to defend himself? And it wouldn't, Your Honors. In this case, he knew he only expecting the 3 offenses that the state was attempting to try to limit its proof to. And he, knew potentially that the state may not make its time frame. That was on, that had been discussed apparently before when we got into this jury out in the motion for a mistrial. And his defense was not timing specific, except for generally, I think we didn't have sex until, much closer to her 18th birthday, which was in May of 2018. So he was saying the time frame was way later, but his whole defense was, yes, I did it, but I did not know she was a minor. So there's no material, prejudicial effect that instead of it being the 3 offenses occurred, within May and September 1st of 2017, it just happened a couple months later, the latest of the 3 offenses. That just is not something that constitutes a fatal variance. So that if there's an issue with the timing, that should be the issue. It's not the state's position. It did not implicate any other problems. Again, with regard to the 3 specific instances and whether they needed to be, the proof needed to show they happened within the alleged time frame. And we cited State versus Green. It's an older Supreme Court case that, in several cases since then that have said that it is not a sufficiency problem. The state can allege a time frame for a specific act. And if the proof shows that specific act actually happened at a different time, then that is not a problem. That's not a prejudicial variance. And the appellant has not responded to those cases other than to say, kind of conflate the issues and say, well, the admission of this uncharged sexual conduct somehow makes all of it a 404B problem. And so the state's not asking this court to ignore any of the Tennessee Supreme Court precedent on 404B crimes. We're really just asking you to look at it. These were 3 specific charge offenses. They only asked the jury to indict on or convict on the 3 different offenses. And the little bit of testimony that came in about uncharged sexual conduct was not something that the state was seeking to use. And so this is fundamentally different than cases where the state starts broad and then narrows down after it's, the jury's heard extensive amounts of testimony about, uncharged conduct. And again, the uncharged conduct that was briefly talked about here was not even like conduct specific. It didn't describe the nature of the sex acts or what specifically they were doing or when they happened. I mean, really, it's very, very minute stuff. I mean, there really, when you read the testimony, not a doubt that the jury was, risking convicting, on a separate uncharged offense. There just was not a lot of discussion about it. And so the state would ask you to affirm on sufficiency grounds and would ask you to find that there's no 404B problem with regard to the time frame or the uncharged sexual conduct. Moving to the other 404B issue regarding the hepatitis B, Your Honors, if you look at the trial transcript, I mean, there was a motion in limine hearing after preliminary jury instructions were given. It was a jury out hearing, which is all that 404B requires. So the state had ticked the box of having I think 404B doesn't require it to be a separate 404B hearing. It just requires it to have a jury out hearing. It did that. And the state, the defendant's argument was this is inadmissible under 403 and 404B. The state's response was, we don't think it's 404B evidence, but we also think it's relevant and admissible for these two reasons. And so, admittedly, the trial court's ruling is not particularly clear. It just essentially says, well, I agree with the state. It didn't say it did not find that it was 404B evidence. It just said, I agree with the state. And I guess I'll just to make sure I get the ruling of the court right. It said, it's a very brief, about like 2 sentences. Okay, I'm going to allow then the evidence regarding the hepatitis. I think it is relevant and does substantially outweigh the prejudicial effect it might have. So I will allow that. So it's applying a standard that satisfies Rule 404B and Rule 403. And so when you have no dispute as to whether the transmission of the STD is clear and convincing, sure, the state can very much in good faith argue that that's substantial compliance with the ruling of 404B, even if the trial court could have made a more extensive, analysis. So we would ask this court to apply abuse of discretion, but even under, de novo review, the state still is adamant that there's no error in the admission of this particular evidence. The state articulated during that jury out hearing and articulated again during the motion for new trial hearing, the purpose of admitting the STD was to corroborate the victim's testimony that they did have sexual conduct, and that it was important for the jury to hear about the timing of the disclosure in this case, which ultimately was essentially part of this, defendant's, his defense was only a credibility attack on the victim. And so the state was concerned that the fact that, she did not make her report until several months after their relationship ended, that the jury, when she, was being hit with all this credibility, questioning, couldn't remember, when she, exactly the offenses happened, that it needed to know why, why the case was even there, that it came up when she got a positive test for hepatitis B. And so those are two non-propensity purposes, Your Honors, and all 404B prohibits is the admission of evidence for propensity. The state never, in its proof, suggested that the admission of the hepatitis evidence was to show, hey, he's a bad guy. He knowingly gave her hepatitis. Therefore, he probably also had these other 3 alleged acts with her. Now, during closing argument, the prosecutor made some references to the hepatitis B that were not consistent with that theory that he had espoused. However, Your Honors, that's a separate issue. The defendant did not object during the closing argument to say, hey, wait a second, Your Honor, the prosecutor is now offering this evidence for a propensity purpose that's different than the basis for why it was admitted in the first place. So, the appellant wants to now kind of point to that and go, oh, here's all the prejudice. Well, that's a separate issue of whether it should have been, mentioned in the way that it was at closing argument. But for what the state was purportedly offering that evidence for when the trial court was considering it, it was being given legitimate non-propensity grounds. And so completing the story under Gilliland is providing important necessary background information is a legitimate non-propensity purpose. And the appellant has acted like the Tennessee Supreme Court has prohibited the use of it for corroboration. And Your Honors, if you look at Rickman and you look at Clark, that is not what those cases say. The discussion about corroboration in Rickman, which had to do with uncharged sex crimes, that they couldn't be used to corroborate the actual occurrence of the charged sex crimes, that whole discussion comes up with the Supreme Court's rejection of a general sex crime exception. So if you look at Rickman on 828 through 830, it explains that is not just a broad, you never can have corroboration. It is saying that the testimony of the victim about other prior unindicted sex crimes allegedly committed by the defendant upon the victim does not corroborate the testimony of the victim that he or she suffered the attack for which the defendant is then being tried. That's the nature of that condemnation of corroboration. If it's being offered to corroborate identity or the fact that the actual event occurred, that's a proper non-propensity purpose. Now, if the defendant agreed, it was, acknowledging that he had committed the acts but disagreed as to the mens rea, well, that may go to probative value, but this is not just a complete bar for this purpose. And then the State versus Clark case, which the appellant cites as essentially saying that admitting the admission of 404B testimony for credibility purposes is prohibited. Well, that was a different situation as well, very distinguishable, where the state used the evidence of Mr. Clark's pornography to impugn his character for truthfulness. And as we've explained, evidence of other crimes, wrongs, or acts is not generally admissible for the purpose of impugning the defendant's credibility. It doesn't say that it can't be used as part of the background context to explain what happened, which then coincidentally will also corroborate, bolster the credibility of the victim. So these are two separate issues with regard to what the defendant is kind of saying. These were illegitimate purposes that the state was offering the hepatitis B. And under an abuse of discretion standard, the state submits that the trial court did not abuse its discretion by finding that the probative value here outweighed the prejudicial effect. And that ruling, the way it said it on the record, that's consistent with both admission under 403 and under 404B. So another thing, real briefly, that the state...
Very briefly.
Yes, Your Honor. Very briefly, when we look at prejudice for the admission of this evidence, the state submits, when you read the transcript, this was possibly the strongest means of credibility attack from the defendant. That the only reason the victim came forward and was testifying and making the allegations she did was because she was mad that she received, her positive test for this STD. I mean, he cross-examined her about that. Now, the cross-examination occurred after the evidence came in, sure. But when you look at the prejudicial effect it would have had once it came in, this was very consistent with the defendant's theory that she was biased because of her, positive test result, that she may have then been fabricating her testimony about what he knew about her age. So, Your Honors, review the transcript. We'd ask you to affirm on sufficiency that there was no intentional introduction by the state of uncharged sexual conduct under Rule 404B, and that the trial court did not abuse its discretion by admitting the proof of hepatitis B. Thank you, Your Honors.
Thank you. You have 3 minutes.
Thank you, Your Honor. I'll start with the 404B, the hepatitis B part. 404B requires more than just holding a hearing. So all I heard the state say was, the trial court substantially complied with 404B because there was a hearing. That's not what 404B requires. There's more than that. At the motion for new trial hearing, the prosecutor said that they did not charge Mr. Griffith with the crime of knowingly exposing another person to hepatitis B because they didn't think they could prove his mens rea. The state didn't think it could even charge him with this criminal offense. So there is likely no way that the trial court could have found under 404B that the crime had been committed by clear and convincing evidence. That's the standard from 404B that was not applied. And by the prosecutor's own statements at the motion for new trial hearing, likely could not have been met. Also under on the prejudice for the hepatitis B, the prosecutor's use of that evidence shows exactly what the state was trying to get it in for. Any credibility issues with Ms. Haley would not have been at issue if this evidence had been properly excluded in the first place, properly subjected to 404B and properly excluded. Turning to the other issue with the uncharged acts, because I think that's probably where the court is struggling a bit more. What the state is characterizing as these minute references in the record, that's what happened on cross. On cross, her response was, her answer was non-responsive. Her first, we did those things, but more than once. That, if it had stopped there, then that is the minute, nondescript, not a big deal occurrence that the state is trying to paint this as. Whatever that question was, and whatever that answer was, any redirect that took the Ms. Haley into testimony that the prosecutor knew existed is far beyond anything that she testified to on cross. And I'd like to point out that and Your Honor will see this in the transcript, when she first tells the prosecutor, I said about every other weekend, the defense objected to the prosecutor's attempt to backdoor information. And the prosecutor says, they stumbled into the issue. Yeah, they stumbled into it because of the way that the prosecutor presented the case. And then at that point, the defense requested a jury out hearing, which was denied. So to imply that the defense didn't do what it could to try and minimize the effect of the error, they did. They requested a jury out in between the every other weekend and the March of 2018. A jury out hearing was requested and denied. Then when we get to what timeline this occurred in, the prosecutor is the one who asked for the third time, would it possibly have been as late as November? Were you still having sexual relations with Mr. Griffith at Thanksgiving of that year? At that point, she had not said March of 2018 yet, but November and Thanksgiving is already 2 months beyond the ending date of the indictment. And this is the prosecutor inviting her to talk about the extended time past the state's own indictment. And the state wants to just ignore that time frame because of the generic sex crimes exception, which the state has acknowledged did not apply here. So the indict broad, narrow down does not apply. By the same token, the specific time frame and the specific counts that were alleged is what the state is limited to. And the prosecutor, and these cases are cited in our reply brief, the state has to elect offenses that occurred within the time frame of the indictment. The time frame absolutely matters in specific allegation cases like this one. The state did not do that. It attempted to rely on these additional acts.
Counselor.
Thank you, Your Honor.
That concludes the day. Thank you. We'll appreciate the argument on both sides. We got time limitations now. I'll let y'all go all day. It's been enjoyable. We got another case to hear. Thank you.
The Honorable Court is now in recess until 3 p.m.